Philadelphia is revered by all Americans, for it was here that 13 American colonies declared their independence from Great Britain. As a new nation, they adopted the Constitution here, that instrument that governs the nation's political and legal process and through which the will of the people can be realized. The Constitution both empowers and limits government. For example, it defines the powers of Congress over such issues as the admission of new states to the Union and the manner by which individuals born outside the duly admitted states hold or may obtain U.S. citizenship. It determines the nation's relationship to territories under its protection, and it is the mechanism by which they may gain permanent political status. Ambassador Richard Tier, a retired American Foreign Service officer, is presently director of a Center for Foreign Policy Study at Georgetown University. As a diplomat, he carried out policies relating to U.S. territories, those entities under federal law that are not among the 50 states, but whose residents live within the legal framework that governs us all, the U.S. Constitution. We ask Ambassador Tier to outline the constitutional factors determining sovereignty and citizenship as U.S. territories consider changes in their political status.
For the next few minutes, we will review U.S. territorial policy and how it is governed by the Constitution. Having negotiated political status treaties, I have become aware of the possibilities and limitations imposed by the Constitution. To understand these issues, we first must understand what sovereignty means under our Constitution. Sovereignty is the supreme power vested in government by the people to govern by law the geographic territory and population of the United States. Article 4, Section 3, Clause 2 of the U.S. Constitution gives to Congress the power to govern territories under this nation's sovereignty, but not states of the Union. Since the first 13 states ratified the Constitution, the U.S. has acquired sovereignty over some 38 populated territories. 32 of 37 states later admitted to the Union had been U.S. territories governed by Congress. Once they had become states of the Union, each had sovereignty specifically guaranteed by the Constitution. Today, the United States governs 5 populated territories, each with a congressionally organized civil government. Each organized territory has its unique geographic, political, social, and economic characteristics, but any political status defined by law or treaty must conform to the Constitution. The oldest and most populous U.S. territory is Puerto Rico. Under the Treaty of Paris of 1898, Puerto Rico, Guam, and the Philippines were ceded to United States sovereignty by Spain. In the intervening 100 years, the U.S. Congress has expressed its sovereignty over Puerto Rico in differing ways. Since 1917, those born on the island enjoy statutory U.S. citizenship resulting from a series of federal laws. Its local governance has moved from the administration of a territorial administrator appointed by the President to its present organization as a Commonwealth, a system begun in 1952 pursuant to congressional legislation which retained U.S. sovereignty but permitted local control of the territory's internal affairs. Today, its roughly 4 million U.S. citizens elect their own governor and legislators, but unlike states of the Union, do not have voting representation in the U.S. Congress or equal rights under U.S. law. Places like Guam, the Commonwealth of the Northern Mariana Islands, American Samoa, the U.S. Virgin Islands, and the Commonwealth of Puerto Rico are all territories that have local self-government in varying degrees, but remain subject to the supreme powers of Congress. We will use this display to discuss the various political status models. This document, representing the U.S. Constitution, must be understood as a wall of demarcation. The wall properly sorts out the political relationships that the United States maintains with entities within and outside its sovereignty. All possible categories of political status within U.S. sovereignty can be seen as being on this side of the wall, while the many forms of governments existing outside U.S. sovereignty can be seen as belonging on this side of the wall. For a U.S. territory to obtain permanent political status, it may do so within or outside of U.S. sovereignty. Depending on the permanent status which it achieves, it will end up on one side or the other of the constitutional wall that separates those within and those outside of U.S. sovereignty. Within U.S. sovereignty, only states of the Union have a political status defined by the U.S. Constitution, a status that cannot be altered without a constitutional amendment. Statehood ends the territorial power of Congress and establishes a constitutionally guaranteed permanent union. Statehood also guarantees U.S. nationality and citizenship, full representation in the federal political process, and equal individual rights. In contrast, the political status of other territories within U.S. sovereignty is defined by federal law or treaty. Any form of political status or citizenship created by a law instead of the permanent provisions of the federal Constitution can be altered by a later law. This is because one Congress cannot bind a succeeding Congress to any law or treaty. Only the U.S. Constitution is permanent and binding. This means Congress does not have the power to promise that a future Congress will never alter the status or citizenship of a territory. There are three categories of U.S. territory that have been created by Congress under federal law within U.S. sovereignty: incorporated, unincorporated, and possessions. Incorporated territories are those that Congress has put on the path to statehood with its attendant equal civil rights and responsibilities. The 32 territories that became states did so in accordance with the terms of incorporation leading to statehood under an admission act approved by Congress. Unincorporated territories are those within U.S. sovereignty, but for which Congress has not yet approved a statehood or independence enabling law. They have local government organized under federal law with a political status and citizenship defined by Congress. A possession is a territory that is within U.S. sovereignty, but which has no organized form of local self-government under federal law. It is merely property of the United States. An unincorporated territory that has adopted a local constitution for local affairs is typically referred to as a Commonwealth territory. Examples include the Commonwealth of the Philippines from 1935 to 1946, the Commonwealth of Puerto Rico, and the Commonwealth of the Northern Mariana Islands. Adoption of a local constitution authorized by Congress does not establish a separate or constitutionally guaranteed sovereignty or citizenship. Even if one Congress states a policy to treat a territory's status and citizenship as if it were permanent, a later Congress could change that policy. There are three categories of relationships maintained by the United States that are outside of its sovereignty: independent nations, separate sovereign nations in free association, and international and regional organizations. A U.S. territory that becomes an independent nation is outside of U.S. sovereignty. Its sovereignty is separate and apart from the United States. It then possesses its own nationality and citizenship. This ends application of the U.S. Constitution and federal law as the supreme law in the territory, and U.S. sovereignty ends. Relations between the newly independent country and the United States are governed by treaty and international agreements to which both parties are signatories. In the case of a territory that becomes independent but is not ready or able to carry out all the functions of national sovereignty, it may enter into a treaty of free association with its former nation or a third nation. This mutually agreed upon treaty of free association is not guaranteed or permanent under the U.S. Constitution. If free association is to be non-territorial and non-colonial, it must be terminable at will by either party. Free association is a form of independence and does not constitute a permanent union. Any rights granted to citizens of the freely associated state, such as unencumbered travel and residency, are not constitutionally permanent or guaranteed. In addition to defining political status, the U.S. Constitution empowers Congress to either grant